was exercising some interconnected rights and freedoms which were guaranteed to them by the Constitution. The very first freedom which was being exercised as guaranteed by the Constitution was the freedom of assembly and political association. Under Articles 19(1)A, 19(1)B, 19(1)C, the bodily integrity of each one of those students who had gathered there were also protected by Article 21, I believe.
Second petitions with license.
So therefore, the state action, if any, would essentially be tested under the scrutiny of arbitrariness in relation to their action under Article 14. Because what followed thereafter, my lord, is something which is unimaginable. Your lordship can see snatches of that which have been placed before my lord. This is a situation where brutality to the largest measure possible has been used in relation to a peaceful agitation. I am not for once saying this, that the state did not have the ability to regulate the movement. The state did not have the ability within itself to channelize the movement.
Can I, Lord, supplement just one?
Yes.
But if your lordship will permit me to supplement, Lord. This gathering had assembled for almost 20 days when Mr. Sonam Wangchuk had already declared about a week earlier that 20th they will march to the parliament. Now this march to the parliament was well known in public domain and everybody assembled ultimately on the 20th. So up to 19th the violence didn't happen because it was all at Jantar Mantar.
Just a minute.
Also outside. 148 and 149 will be relevant, Lord,
Please go that side.
of BNSS, which provide for what kind of force can be used.
My friend, we are not in an adversarial situation.
They are here clouding us. No?
Please give space.
So please have them on.
Please give space. No, I am not herding anybody. I am not a cowherd.
So, Lord, the assembly started swelling on the 20th because of this information which was in the public domain of that march on the 20th to the parliament. And it is that assembly which was attacked at Jantar Mantar, where all these innocent boys and girls, and Lord, boys and girls from all families where, Lord, are like, for instance, Lord, a senior advocate of the Supreme Court, Mr. Hegde's son was also there. He was also in the same protest. Similarly, Lord, children from
all walks of life.
All walks of
We are
life.
not claiming any status here.
Doctors, paramedic staff, they were also there, Lord, because they also had their own grievance with regard to the, Lord, NEET examination. Now, what is important is, Lord, that the use of force on a peaceful demonstration, there is till date not a whisper in the public domain that the people who had assembled there turned violent. On the contrary, Lord, there are videos which I am placing on record,
Lord, I have just
where
sent
there is
across
a person
pen
in civil clothes sitting with a lathi. Several people in civil clothes sitting with a lathi, and they, along with the police, have attacked these the assembly. These people, these innocent people.
If your lordship will
Now,
kindly
that is something
see,
which is, Lord, very.
there is a
police
pen
is
drive.
Sort of, Lord, taking.
There is a pen drive which I have given to your lordship for your lordship's consideration. There are a series of videos which your lordship will see where all kinds of violence is being perpetrated. As my learned friend had just said, there are lathis which are having nails onto it by which the children are being beaten. There are pellets which are being used. There are not only pellets, there are electric batons which are being used to give electric current. If this is the manner in which a peaceful demonstration will be dealt with, which was well within its
not
rights.
a whisper anywhere till now.
If your lordship for a minute will see the videos for a minute, I want to take you through them.
That anybody in the assembly turned violent. There is not a whisper, my lord. Not a whisper at all. So that is why, and every policeman by law is supposed to have, Lord, his name His name mentioned on his dress.
Can I just show?
The names were not mentioned.
The videos we show.
My friend, can you just hold your breath for a moment?
If your lordship can just have a look at the videos.
We will watch the video later. Please make your address.
My lord, this will go side by side along with the submissions because it has got a context. How do we place it in context before my lord that there was excessive use?
So you are asking us to watch the video.
I'm just,
To assert a point
yes,
that the use of force to disperse that assembly was excessive.
excessive. It was uncalled for to begin with.
Maybe that is why it was uncalled
My lord,
for because
the-
it was excessive.
So long as the demonstration was peaceful, I myself opened with these lines that the police or authorities may have a situation where they can regulate a crowd because the object of the crowd at no point of time was unlawful. The object of the crowd, essentially the object of the assembly, was a legal object in the sense that they wanted to ventilate their grievances in relation to the NEET examinations. And they had a right to do so.
But just see section 148 and 149.
Let him finish. No, we can't go to and fro. One person finish. Please.
Now, if my lord would see that as far as a proclamation also under the erstwhile situation of 144 which existed then, now currently it has turned into 163. That proclamation was also not there in place. There is no circular which shows that that proclamation had been made. That people are not being allowed to assemble. So in this kind of a scenario, my lord, where a 163 circular is not there, the magistrate had not been called upon to come there in that area. If at all it is their case that the crowd turned unmanageable at some point of time, or it took to violence at some point of time, there is a particular manner in which it has to be dealt with. Adequate warning was to be given. There is not a single instance where they can show that there was a warning given to the agitating people that please disperse. Otherwise, force will be used against you. There was no whistle blown to say that now force is going to be used against you in this fashion. If I go back to colonial times, in colonial times also, when 144 was in place, these were the basic necessities which were supposed to be adhered to. Nothing of that kind happened. And then the kind of force that is being used, the force which is to be used, there are umpteen judgments which say that it has to be proportionate to the cause. It can't become a situation where you are taking it out on the protesters for being there, or that the policemen are finding it hard to perform their duties, so therefore they take it out on the children. It has gone down to that extent. It is retributive in nature. They were unarmed people. It is not their case that the children at any point of time were armed. And they exercised force against the police forces there. Now, this kind of a situation, my lord, where you are beaten up black and blue. The ladies in the said protest, the lady students in the protest are being molested. Your lordship will see all those videos as well. That is why I wanted you to have a look and place it in context. At least those officers who are identifiable, committing cognizable offences, my lord, against them, registration of FIR should be made. On a plain viewing, your lordship can see that there are cognizable offences being committed. And an inquiry be made into the entire incident. I am not for 1 minute saying that people who have caused injuries to police officers, they should be let off if they have taken law into their own hands. More than 90 people have suffered injuries as far as students are concerned.
Oh, there is no allegation
And the list is growing.
that any police officer was hit.
No, I am just as a matter of abundant caution saying this. And some kind of, my lord, directions need to be passed
To
in relation to,
preserve all CCTVs, but that will be very, very.
in relation to the fact as to when a situation like this happens, what is the code of conduct that the law enforcing agency has to maintain.
Can I just supplement for 2 minutes?
Then one more aspect, my lord. We are also, if your lordship sees the prayers, in the prayers we are also asking the preservation of all the material, which includes the video recordings, the CCTV cameras at various places, the Rose Ramchas, the circulars which they said came into force, the directions by which the police officials acted, who gave those directions, all that material needs to be preserved. Where's the petition? If your lordship sees the prayers, we are seeking the setting up of a special investigation team or any independent agency which your lordship may think to inquire into these incidents. And we can't have the Delhi police investigating into this when we are alleging that they are the ones who have used excessive force. It has to be some independent agency. And those who are identifiable, my lord, we have given the material before the honorable court. Your lordship will see that these are instances where the person is clearly identifiable. There are policemen who are slapping ladies, molesting them, using batons in their private parts, if I may say so. It is so ghastly. In prayer 6, we say, my lord, we are asking for preservation and production of all CCTV footage. If there is drone footage, that can be called for. Body-worn camera recordings, videography, wireless communication records, PCR logs, deployment orders, orders pertaining to the use of force, lathi charge, tear gas, batons, and tasers, which were used as if cattle was being herded with electric shocks. We also beseech for the constitution of a high-level judicial inquiry, my lord, or an independent inquiry at least. Otherwise, we won't get to the bottom of this.
Yes.
These incidents took place on 20th July 2026. I speak for myself and I say that I've gone through about 130 of these videos. They're all been uploaded, they're freely available, and we have had them verified as well. Why the videos are relevant in this case are the following. The videos reveal this. One, there are a large number of people who purported to be police force were in mufti. They were not wearing their police uniforms. Even those wearing police uniforms didn't have their badges on them. So whether they were police people, we don't know. But we do know that they were armed. They were armed with lathis and they were armed with excessive shock-producing batons, which are not even prescribed for the Delhi police and the RAF who were deployed there. The second, the video shows specifically DCP Sandeep Lamba, that is his name, his badge is captured, slapping a woman who is standing innocently on the side and doing nothing. She's not moving. I can show you that video right now. DCP Sandeep Lamba is his name. Let's not be additional DCP. Let's not be scared to name our thugs in uniform when they deserve to be named. He should be summoned here and he should be asked to be accountable for his actions. Third, this is after the crowd was dispersed. There was no heat or fury, no crowds, nothing. Completely unprovoked. He's walking past two women, he reaches across and slaps one of them across the face. These are the people that we put in charge of our police force to protect us. And that's why we are before this court. The Supreme Court, while dealing with this in 2012 in the Ram Leela case, very specifically went para and verse into the various standing orders and the procedures that are laid down, said they were dissatisfied with the existing standing orders, gave specific directions for standing orders to be issued by the Delhi Police Commissioner, who's respondent number 1, with reference to protests like this. Till date, we don't have such a standing order which has been issued. We have only one of 2011. What the Supreme Court said in Ram Leela Maidan was that in that particular case where Baba Ramdev, etc., had been responsible for fomenting some of the police action, here there has been nothing. Nobody provoked anything, absolutely nothing. what the Supreme Court there said is that the first step you will take is ensure knowing the numbers that are there. And as Mr. Hariharan and Mr. Singh said, there were hundreds of thousands of people already there for the last 20 days. And they knew that this was a date. So the first step you should have taken was to ensure you follow your protocol and you have announcements of how you are going to disperse. Second, you will have enough and sufficient water cannons. In Ramlila, they did not, and the court frowned upon that. You will have enough water cannons as the first step. Here they had one water cannon, which from what I understand was not deployed at all. Tear gas will be the last option and you will not deploy it. They threw it at mothers, wives, small children. There are men standing there with 3-year-old children on their shoulders. Photos and videos will show you that. Tear gas was thrown at them. Canisters were thrown at them. The further instruction is that when tear gas is thrown, it will be thrown away from the crowd and not at them. The number of injuries that happened were completely and solely because of the actions of the Delhi police, the RAF, and those who claimed to be Delhi police and RAF. The videos will also show your lordships, as has already been mentioned, that there are lathis with nails which are not one instance of any action. And I'm telling you personally, as an officer of this court, I've seen 110 videos. I sat it till the kind of bullying and madness which has captured the imagination of these people purporting to be policemen, that they wear helmets, they're wearing t-shirts and jeans, they trip up a protester who's trying to run away. And when he falls down, 4 of them get after him with batons and start beating him with lathis. This kind of excessive force, if the constitutional courts don't step in and stem, it's a license to the police to just get away with absolutely anything because they know they have the sanction of the political masters. It is here, my lords, that we must be accountable. And we need to have them explain their actions, and which is why our prayers include that apart from an SIT, an FIR against these so-called police officers and administrative disciplinary action taken against them, we need to have a judicial inquiry as well. As far as the preservation of records, I think we have enough and more records in any event. There are multiple. Today, every single human being who's walking around with a cell phone is a journalist. There is enough and more video proof. There is also, and this one is unverified, so I'm putting a caveat on it. There is a video of 6:30 on the morning of 20th, where you find a journalist being taken along with one of the volunteers who shows a car which has been parked just that night with its windshield broken, its side smashed, and he says they've brought it and parked it here so that they can blame us later that this happened. There is also another video which shows at 6:30 a.m. in the morning a truck full of bricks and stones, which you can't see from the side, but if you climb up and look in, it's full of bricks and stones which are kept there. Nothing brought by the volunteers and the young people who were there protesting for our rights, the rights of our children and our grandchildren. And it's for them that Gandhi laid down his life, and generations of our people laid out their lives for protesting against foreign colonial rule, and we have to put up with this now. I'm grateful, my lords. I just believe that notice has to go to them and some strict action be taken independently.
Lord, in the third matter, there are 2-3 statutory provisions which
my
I
lords,
want
may
to
I be excused? I am an amicus in one matter. I just words.
There is, Lord, a standing order of the Delhi police, which is quoted in the Ramlila case, Lord. If your lordship have that judgment, your lordship can see there. That judgment is, Lord, 2012-5 CC.
This one?
Yeah.
Anita?
Yeah.
Give the paragraph.
Paragraph will be, Lord, 321. 322. पूरा citation क्या है? 2012-5 SCC page 1. Just pass one copy at least. Para 322. If your lordship will have kindly, Lord, internal page 122, where your lordship will find paragraph 322. Now it says Delhi Police Standing Order 309. regulation of procession and rallies prescribe the mode of service of the order passed under 144. So there was no 144, but they are assuming in this case that there was, in that case, there was a 144. So what
Can
is
you
the
pull out
arrangement
the-
to be in place of a
Himmat Lal
demonstration
Kesha.
if there is a 144 in place?
SCC 973.
Display of banner indicating promulgation 144. So if there was a 163, that was to be displayed there. Not displayed, obviously there is no 1.163. Now please see number 2. At least 2 videographers be available on either side of the demonstration to capture both demonstrators as well as police response oblique action. Then location of ambulance PCR van for shifting of injured persons. D. Loud hailers should be available. Repeated use of PS system, a responsible officer appealing and advising the leaders and demonstrators to remain peaceful. Now here there's no question of making an appeal because there was no violence. This is in a case where actually they resort to violence. This is not, our case is not where there is any resort to violence. So this is dealing with that situation. Repeated use of PS system, a responsible officer appealing, advising the leaders and demonstrators to remain peaceful and come forward for a memorandum, deputation, etc. or court arrest peacefully. Announcement should be videographed. If they do not follow the appeal, then turn violent, declare the assembly unlawful on the PS system and
Mila?
videograph. Warning on PS system prior to use of any kind of force must be ensured and also videograph. Now, Lord, please see section 149 of the BNS. The other instruction of Delhi Police Lord says that they should be having, all the police officers there should be having their names on their uniform, so that if there is a video taken, it should be captured.
Nobody had anything.
None of them had any nameplate on their uniform. That is brought in the general instruction that I just handed over to your Lordship.
Page 154.
At page 154. This is part of DK Basu.
And I want you to take out this.
This is that instruction brought with regard to nameplate of the police officer. This is that instruction. Now, Lord, please see after that, please see Lord section 149, the BNS. Or in fact, it starts with 148. Any executive magistrate or officer in charge of a police station, or in the absence of such officer in charge, any police officer not below the rank of a sub-inspector may command any unlawful assembly. So here there is nothing to show that it was an unlawful assembly. This will apply. I'm going to the worst to assume that it is an unlawful assembly. So to command any unlawful assembly or any assembly of 5 more persons likely to cause a disturbance of public peace to disperse, and it shall thereupon be the duty of the members of such assembly to disperse accordingly. So this is the worst thing which they can argue against us. Now, Lord C2, if upon being so commanded, any such assembly does not disperse, or without being commanded, if conduct such a manner as to show determination not to disperse, any executive magistrate or police officer referred to in subsection 1 may proceed to disperse such assembly by force and may require the assistance of any person not being the officer armed forces and acting as such for the purpose of dispersing such assembly, and if necessary, arresting and confining persons who form part of the order to disperse. Then see 149. If any assembly referred to in subsection 1 of 148 cannot otherwise be dispersed, and it is necessary for the public security that it should be dispersed, the district magistrate or any other executive magistrate authorized by him who is present may cause it to be dispersed by armed forces. Then please see subsection 3. Every such officer of the armed forces shall obey such requisition in such manner as he thinks fit, but in so doing, he shall use as little force and do as little injury to the person and property as may be consistent with dispersing the assembly and arresting and detaining head persons. Now, hitting on the head can never be permitted under this section. So, firstly, Lord, what we require from your Lordships today, Lord, is that they should preserve. They are supposed to maintain video cameras on both sides. One will be capturing what the police is doing. One will be capturing what the demonstration is doing. So that is their own requirement, statutory requirement, which they are supposed to maintain. That should be preserved. And your lordship should also, my lord, ask that if there are, because there are a lot of body cameras which a lot of these people carry, those body cameras should be immediately, my lord, seized. Because if that is not done, no proper inquiry in future will be possible, my lord, because it will be my word versus your word. And I don't want that situation to happen. This is a very, very serious case, my lord, where these are all innocent children or families or mothers or, my lord, doctors or lawyers who have assembled there only because of the what is happening, Lord, in the NEET, Lord, for year after year. The rich are able to secure a government seat, and the poor go down in the merit list and they have to pay for the private seat. So the rich really, because whatever they have to pay to a private college, end up paying underhand and get a government seat, which is a lot more prestigious, where you don't have to pay much of fees, and it ultimately benefits, Lord, them. It really doesn't cost them anything extra except that they have to pay it underhand, and the poor get into, and that's the angst which is not there all over the country. People are committing suicide. People are not selling their jewelry and their land to not educate their children, send them to coaching classes. Now that angst is unfortunately not, in my respectful submission, not dealt with properly. Even the act that they have brought in 2024 only targets the last man who is doing the selling of that paper. The Act of 2024, which is for the purposes of public examination, Lord, does not go to the mastermind of whoever is doing this and how he is doing this. That act, in fact, there is a separate petition, Lord, in Supreme Court, where a prayer is there, which is also pending. But notwithstanding that, I can say, Lord, as a responsible officer of the court, that that act is not sufficient to, Lord, take care of this NEET, which kind of this is happening. In fact, Lord, the statistics are that in the last about 7-8 years, at least, Lord, 20 public exams have been rigged in some manner or the other, either question leak or dummies
Let's
sitting.
not enter into that issue.
No, I'm only wanting to, what was the purpose of saying that is only to show, Lord, why all these people assembled there. The purpose is only to show that this was a general, Lord, discontent amongst the people of this country who felt that we need to assemble and raise our grievance and bring it out. So the bottom line is, it was peaceful. The bottom line is, it was not unlawful. And the last line is that even if it was unlawful, there is a method to be done. It can't be done in the manner in which it was done in this case. So your lordship will issue notice, ask for the response, and in the meantime, ask them to preserve all this, because that will be very, very important.
May I make a few submissions, my lord? I am led by the Solicitor General, my lord. As far as the examination and leakage of paper, no, there can't be any doubt or there can't be any second view that.
SG, Mr. SG, kindly
I'll-
wait. There is another petitioner who has to address the court. Yes, please. Use the mic. Use your mic, please.
I'm for the petitioner in item number 54, and my petition is based on the incident which took place on 18th of July in the morning when the Mr. Sonam Wangchuk sir was taken out from the protest site. Malad, the procedure which was followed by the police, that was very illegal. Why, my lords, I'm saying? Because the procedure was taken, applied by them, that all the police officials, they were acting like a local goons. I'm sorry to say, but this is the truth, my lordship. My lordship, they had no any uniform, they had no any badge in their uniform or civil dress, my lord, and they forcefully entered into the stage side to force, to thrash, and to beaten other protesters, my lord. And directly they approached to the stage where the Mr. Sonam Wangchuk sir was lying. Second thing, my lord, that all those protesters who were trying to stop them, so all of them were being beaten, black and white, my lord. Third thing, my lord, that all the police officials were acting like they made the entire stage was totally cordoned by a white seats, my lords. And they were showing like either they are taking a person who is either a terrorist or a anti-national person, my lord. Malad, nothing is happening there. They were on hunger strike, and for the 21st day, Malad, that was the 21st day incident, which shocked all entire nation, Malad, because it is our right, fundamental right. Article 19(1)(a), 19(1)(b), Malad. These are the fundamental rights, and the entire constitution is based on this basic foundation, Malad. If I cannot express my dissent, Malad, then who will, and what weapon we have, my lord, except this? Because we are demanding for our good education, quality education, my lord. So it was particularly the demand of the protesters. And what happened that, and my lord, and one thing is very surprising and very shocking, that when the Mr. Sonam Wangchuk was taken out from the protest site, and thereafter the DCP New Delhi posted on their ex official portal that whatever the step we have taken as per the direction of the Honorable High Court. My lord, I have annexed a order copy.
That's not the
Sorry,
issue here, perhaps. That is not the issue here, perhaps.
my lordship, it is an issue. It is an issue. Why I'm saying, my lords? Because on 16th of July 2026, this honorable court had passed a direction that whatever the medical requirement is necessary for Mr. Sonam Wangchuk, that should be provided by the state, by the government doctors, my lord. But the police, when they took out from there, and they are saying that
All
we have
that
done.
issue was taken up
Yes.
by the wife of this person. That has included.
Later
Let's
on,
not go into all that.
please. My lords, later on, or writ petition in the name of Mr. Rakesh Kumar Saini versus Union of India was filed. And this honorable court had given direction for ensuring medical safety, my lord. But no any direction, my lord. I can read the order which is in my hand, my lord. Writ petition number 9498 of 2026. Yes.
You have made
Yes.
a point that notice the issue.
My lordship, my prayer is also similar to the other petitions also. So kindly be considered, please.
Mr. Sharma.
Raju is there.
My lord, may I submit, my lords?
Yes, yes, please.
I'm led by the Solicitor General, but he is busy in some court, therefore I'll proceed with the matter. There are two things, my lord. This last 54 is different from the other petitions. My lords may kindly note. As far as 54 is concerned, the date of the incident as well as the event are totally different. According to even the petitioner in 54, no cognizable offense is made out. His prayer, kindly have a look at his prayer, my lords. His prayer is find out if there's a cognizable offense. If there's no cognizable offense, there can't be a registration or FIR. That is, prayer starts at page 18, my lords. Therefore, my lords may kindly have a look. His case stands on a totally different footing. He was not present at the, it is not as if that he was present at the place of the incident. If at all any cognizable offense has been committed, you can always move the court under section 156(3) of the old CRPC. That is the right remedy. There are a series of judgments, my lord, which have taken this view. Number two, my lord, as far as the person concerned, my lord, Mr. Wangchuk or his wife Sonam have not filed any complaint, have not raised any grievance. And this
My
court
lords,
is seized of the matter. This is like something, my lord, there is this, it seems to be that this is a sort of publicity seeking petition, because this involves a lot of publicity. So many people are interested. Therefore, you raise this petition, and therefore, this on this ground alone, the petition is also required to be dismissed. This is as far as 54 is concerned, my lord. As far as the other petitions are concerned, my lords may kindly have a look. As admitted by, we have not admitted anything, but as admitted by Mr. Hariharan, some police officer. Somebody has unmuted me. Am I audible now, my lord?
Yes, yes.
Mr. Hariharan has said that some policemen were injured. Then he later on.
I didn't say anything. I said that if there is an
Later on he
injury, that can
corrected.
also be inquired. That's all.
He later on corrected, that's my alternative submission. Now, there can't be an alternative submission on whether a policeman is injured or not. There can be an alternative submission on law, but not on facts.
No,
My lords, may kindly
we
have
are
a
saying that kindly determine the
look.
facts.
It's not, I never interrupted when you argued, Mr. Hariharan.
Don't twist
Therefore,
my
they are
arm
not
to argue what you have to argue.
I don't need your permission, sir. Now, kindly have a look, my lords. As far as this petition is concerned, it's not based on any personal knowledge. Some social media videos they are relying upon and they are saying that we are relying on this. On the other hand, they are saying that if the CCTV footage and the so-called body cameras, if there are any, if they are not preserved, then there will be no case. It will be my case against your case. Therefore, today on this statement alone, that if the CCTV footages are not preserved and body cameras are not preserved, then they don't have a case. The petitions are required to be dismissed. This is one contention. Number two. But as far as there are videos also which show that policemen were injured. Some people may be in plain clothes. Their allegation is that they are policemen. But it's a well-known fact that in such types of so-called peaceful demonstration, which was in fact not a peaceful demonstration, there are instances where the so-called peaceful agitation is hijacked by others. There are political parties who want to take advantage of this. There are other who have some. Somebody wants to take advantage of these facts. Therefore, the so-called peaceful agitation did not remain a peaceful agitation. There are videos where these vehicles have been damaged, serious damages. In a matter of fact, some policemen were injured. I am told, but I have not got instruction. I'm told that a fire has been filed where the crowd resorted to crowd became unruly, resorted to violence. Now, if violence is there, then my lords may kindly have a look. The police have to act. The violence cannot be permitted to go on. Whether the police acted or not is something which I'll address after I take instruction on the matter. Now, my lords may further say that as far as the crowd is concerned, there are videos which show that the crowd was indulging in stone throwing. As admitted by them, there was a truck lying with stones and bricks at the place of the incident. To get away from the fact that this was accumulated by them, they are now saying that it was brought by the police, which can't be believed prima facie. And it is lying there. It was meant for, maybe or not, some persons in the mob might not have done it. There are other elements in the mob which might have resorted to this. My lords are aware that if you are a party to a mob, if you are party to an unlawful assembly, anything and everything which has been done by an unlawful assembly is attributable to the settled principle of criminal law. So these are all matters which are in the realm of just guesswork. People want to take advantage of this fact. They want to get publicity. They will file PILs, come into limelight. Therefore, if they have any grievance, let them move the magistrate's court with concrete facts, their FIRs, and if they make out a cognizable case, the courts are there to register FIRs, and the court will definitely register it. Right from Sakiri Vasu, the apex court has held that in such matters, they have a proper remedies to file a complaint before the magistrate's court and not rush to this court under 226. My lords may kindly also appreciate that they have not resorted to 156(3) remedy. They have not even gone and filed an FIR. At least they have not said so. Then it's not even their case that the police refused to register an FIR. If a cognizable offence is made out, the police are duty bound to register an FIR as stated by Lalita Kumari. Therefore, now as far as 144 is concerned, from social media also it is apparent that 144, which is 148, 163 of the new BNS, it was promulgated. If they have that, therefore it shows that they are only partially putting the facts before this court. True facts are not being put, despite they say that their information is based on social media. If that information is based on social media also contains, other media also contains that there was a notification under section 163 of the PNSS, which is equivalent to 144. They should not have suppressed this fact. And therefore the petition, though looks in the first blush to be very attractive, it is not so. It is based on suppression of facts. It is based on facts by persons who were not present at the scene of the offense. It is based on social media recordings. Social medias have been known to be tampered with and tinkered with. So today there is nothing. These petitions are only publicity-seeking petitions so that they can hog the limelight in an issue which there is a lot of publicity. So these are all petitions with ulterior motives. The persons who are injured, the persons who have actually been beaten, have not come forth and lodged any FIR. They have not come forth and filed a petition. These are all allegedly beaten. I'm sorry, allegedly beaten. Therefore, this is persons who want to take undue advantage of this fact. Therefore, these petitions, even this, do not warrant issuance of notice. In this writ, he has said, in the first writ 54, he has said that he has given a complaint to the respondent. If the complaint given to the respondent is not adhered to or not acted upon, there's a remedy in the end of the BNSS. Old 154(3) has a remedy that if it is not acted upon, you go to the higher officer. And Supreme Court says, if still it is not acted upon, you go under 156(3) to the court, or you can even file a private complaint. If you have the evidence in the form of videos, you say there is videos which show that this offense has taken place. So you have the evidence. So you can file a complaint, rely on this, and then undergo the process of law which is required. So this is not even a case where notice is required to be issued. This is, as I said, this is a petition for hogging limelight, getting publicity, and it is not maintainable in the eyes of law. But this is what I have to say at this moment, my lord. I have yet to take instructions in the matter, my lords.
Not only factually.
So all
my
this is being
client
said without
57 was
instructions.
there also. He said so. He was there in this.
Mr. Raju,
Yes, my lord.
Turn
Yes,
nonsense, I to all
yes.
this.
2-3 questions to you.
Yes, my lord.
Is it a case of some isolated individual incidents? Perhaps no. This is one. Number two, if it was an unlawful assembly, as you say, well, subject to further arguments and subject to further submissions and records which may bring on record to bring on our record. If it was an unlawful assembly, there is a law how to deal with it.
Yes.
There is a judgment of the Supreme Court in Ramlila ground, and there is another judgment.
Ramlila was.
Just a minute. Just a minute.
There is our own High Court,
So
my lord,
if-
on this,
if-
P.V.
if-
Kapoor's judgment.
If these issues are being raised in this PI, how can you say that every individual should go and lodge an FIR?
No, I'm not saying.
It is.
I'm not saying that, my lord. As far as Ramlila case
No,
is concerned,
has it been an isolated individual incident, maybe 10 or 20 numbers? Situation would have been different. You would have been correct in asking them to approach the magistrate or the police station itself first, and then in view of Sakiri Vasu magistrate, or even they could have lodged a private complaint under the old provisions of section 200, 201. But this is not such an incident as is being asserted by them. Whether or not, we are not saying that whatever they are saying is correct. We are also not at this juncture in a position to verify the videos. So therefore, we will only ask you to file your responses.
fair enough, my lord. May I only point out two things?
In the meantime,
We'll
Lord,
file a response.
The preservation
We'll
of
file
the
a response. I
record,
have-
my lord,
I mean,
police
I will
record
file a
to be
response. I
preserved.
would like.
We will pass separate order in 54, but so far as 55, 56 and 57 items are concerned, please file a response.
My lord, we will
preserving-
also ask for preservation of police record
Video
or
is
all
there.
those materials,
By
otherwise
law,
it'll all be
we have
lost.
There is no 55, not 56. and-
56
You have to
and 57.
specify, you
There's no-
have to specify which records.
Yes, I am specifying. Please see the prayer.
Which policeman had a body camera, which policeman did not have a body
Under
camera.
Rule
Then where are the
309
CCTV?
of your
Which
own Delhi
CCTV?
police rules, what you are
can't have a
supposed to
vague
maintain
order
is
and
what
a
you are
vague
supposed to
prayer and a
preserve.
vague followed by a vague order.
ठीक है
What is that? Hmm? Wait a minute. See. Their own CCTV footages, my lord, your lordship may ask them to produce.
Which they are supposed to keep with regard to the protesters and with regard to.
We'll ask them to preserve it. That's
Yes,
Yes,
preserve
yes.
it.
That will
And
help.
also the police logs, the PCR records, all that is required. And including the orders under 154, 144, which my friend is saying that was there.
My lords may appreciate that if a cognizable offense has been committed, it comes to the knowledge of the police, they will take action. There's no doubt about it. That
We'll
they
record-
are bound to take action. If a cognizable offense is made out,
Correct,
and and the police, it comes to the knowledge of police, the police
Mr.
will
Raju,
take action.
Mr. Raju, there is a judgment by Honorable Supreme Court in this region of Jammu and Kashmir. There, these wrongs, remedy can be taken under the public law remedy as well. It can be a liability under public law as well.
This is class
Apart
action.
from the individual tort, apart from the individual criminal law, apart from the individual criminal liability, this kind of an incident, whether correct or incorrect, we are not on that. An assertion has been made, and this kind of incident can give rise to liability in public law as well.
Beyond that, you will.
My lords are right, my lord, my lords are right. But they
Therefore,
must
we are
make
only
out, they
asking-
must make out a case.
Yes, without making any observation, we are only asking you kindly file your response
And
Very
preserve
well.
the record.
And preserve the
I
records.
agree.
and preserve the records
Agree.
in terms of your SOP.
Can I be excused, Lord?
56 and
Can
57.
I be excused?
Yes,
Deep, my lord.
56, 57.
IFOs cannot be.
Let reply, let
What is the
affidavit in reply
No.
be filed by the respondents. ऐसे लिखिए, heard, huh?
No waiting.
May I be excused, my lord, I have a matter which is called out.
Right, all right.
Grateful.
So in all the three petitions, Umesh Kumar, who appears in Umesh Kumar?
I am in 56, my lord.
Umesh Kumar is 56. Umesh Kumar.
I am in 56.
We have implemented National Human Rights Commission. Have you approached them?
Yes, my lord. I have
They have also been approached.
Huh?
no response yet, my lord.
They have also been approached. There's a representation which has also been annexed.
Yeah, all these 56, 57 issue notice. Returnable on, give a date after 6 weeks. On behalf of respondent number, Delhi Police and Union of India. Who appears, Mr. Sharma? Has put in appearance and accepted notice. Heard the learned counsel for the petitioner in these petitions, namely Shri such and such, such and such, such and such. On behalf of Union of India and Delhi Police, Mr. Sharma. Mr. Raju appears for Delhi Police also.
Yes.
On behalf of Union of India and Delhi Police, Shri S.V. Raju Lande ASG and Shri Chetan Sharma ASG have been heard. First. Let a counter affidavit on behalf of the respondent be filed within 4 weeks. 2 weeks time thereafter shall be available to the petitioner. File the joint affidavit, if any. List on such and such day post. In the meantime, we direct that the relevant record in relation to the incident as mentioned in the writ petitions, including the CCTV footage,
That is the petition.
comma, videography,
Lord's records in
If any.
terms of the SOP.
if any, shall be preserved in accordance with the SOP in place issued by the Delhi Police or
309.
the government or the Union of India. List on such and such.
11 September.
Please.